Every day in the USA, people find themselves in court.
Okay, David Torres is called next. That's you?
Yes, sir.
All right, two cases here, 24 CR 844 and 845. And I know you probably bored about hearing us talk about these things, but it's important that you keep being reminded so that you're fully aware of what it is you're facing so that you can make the most informed decision on how your life will head one direction or the other. You were charged with a state jail felony of burglary of a building in 24 CR 844, which you probably know carries with it up to 2 years in prison. In 24 CR 845, you were charged with assault on a public servant, a third-degree felony, which carries with it, if convicted, up to 10 years in prison. All right, David Grove is your attorney. I think this is an announcement on these two cases. What are we announcing today, David?
Your Honor, Mr. Torres, we have reset the case to find out about some restitution in the case.
Yeah.
And I have been told by the prosecutor that the complainant will not get back with them to give them any restitution, which I think would be rather substantial. And so therefore, the offer for Mr. Torres is 15 years. And Mr. Torres wants to reject
On the state jail
I
felony?
made a cap of 15 offer. It's a state jail felony with the assault on a public servant that is enhanced due to his priors. They're not alleged in the indictment, so we do need to file a notice of enhancement. He got 18 years on a burglary of a habitation back in 2015. So the state has made an offer of a cap of 15 years on the assault on a public servant.
So it's 2013.
that. Judge, she's
On,
correct.
it's always on or about. Yeah.
She's correct. She made this offer. She indicated she would be
Well,
fine.
y'all gonna go some kind of
Just a notice
a
of
notice
enhancement.
of enhancement. That means the state jail felony would not changed, but the third-degree felony then can be punished as though it were a second-degree felony punishment, right? So he's looking at up to 20 years in prison for that. What was the offer again?
A cap of 15.
A cap of 15. So he would be looking at deferred or one option is deferred or unadjudicated probation up to 10 years in length.
Yes, sir.
He could be placed on
Up to 15 years. probation.
stand by. Hold on.
He is charged with assault
Yeah.
on a public servant.
Okay, so he's not eligible for regular probation on
Not
that
with the
one.
court, no, sir. And he's not eligible from a jury because he has been previously convicted, is the way I read it.
So he's got, the options are deferred or unadjudicated probation or flat time, which would be in the state jail felony, no less than 180 days, up to 2 years. And in the third-degree felony, enhanced to a second-degree felony, no less than 2 nor more than 20 years confinement.
Yes, sir.
I think those are the different options that everybody has to be considering.
Before the court sets this for trial, which I think would be probably the next step, if we can't work out anything, I believe Mr. Torres would like for me to contact the victim in this case and see about the restitution. If they don't want the restitution, which is what's being indicated, I guess, but this is a business and I think they might want the restitution. If we could reset this for a couple of weeks. And this is not because the state hadn't done their job, because they have contacted them,
Hold on, though.
but I
The
have.
assault, how would that affect the
It
assault?
will not affect the offer. The state's offer will remain the cap of 15. We would just add the restitution onto the cap of 15 if there is any, but
Yeah, what I'm saying is, what I was gonna say is that really wouldn't have an effect on the assault on a public servant, whether the burglary of a building. It would have an effect on that case, but that in the end of the day, that's the much lesser
Yes, sir.
serious offense than the assault on a public servant, and that's where the decision probably will be centered around is the facts and the circumstances of that offense, I'm thinking. But But on the burglary of a building, it, number one, why would you even? You certainly can do whatever you want, but she says they're not getting back and they don't seem interested in getting back with her. Why would you want to open that door and go, oh yeah, now that you mention it, I do think maybe he owes some, I don't know, maybe a sleeping dog, let a sleeping dog lie is not a bad idea, but once again, I'm talking out of school and that's y'all's business. But at the end of the day, the burglary of the building, I don't think is.
In other words, if I
That,
understand.
that is not, to me, if it were in front of this court, the burglary of a building, it's serious. And there's some involvement of what appears to be damage. But the assault on a public servant with the prior conviction is under law, what is the elephant in the room? 20 years, up to 20 years imprisonment, up to 2 years in state jail. It's clear which one is most significant more significant than the other. And let me look at something here. Well, this all happened at the time the police were investigating this
The burglary,
burglary of
yes.
the building. Okay, this is the Bone and Joint Clinic?
Yes.
Yes, sir. Certainly, Judge, I'm not trying to say that should change.
No, I'm trying to figure out what the facts are here, and it says was in a gown. Normally, we don't get cases where someone is wearing a half gown, burglarizing a building, and
Yes, Your Honor.
looks like. Was he in the facility?
He was in the facility.
As a patient?
No, he was not a patient. He broke in through a glass, stole the hospital gown, and was wearing it when the police found him.
A half gown?
Yeah.
Where the back, your buttocks and all is showing?
Yes.
I don't know, Judge, about that particular point, but he was.
Because that makes it
wearing a
hard
gown.
to just run down the street without getting noticed.
Well,
If you're fleeing from the scene of something,
yes, sir. This was after the clinic was closed and everything, but I believe he did substantial damage in entering the clinic. But then was found by the officers basically asleep, I think, and wearing a gown. And they just say he's wearing a gown, so I don't know. Miss Stahl probably got to see the photos, and I haven't seen those yet. I don't doubt what she's saying. I'm not saying that. But if that won't have any effect, Judge, on whether there is restitution or not, won't have any effect on what the offer is, then.
what happened on this criminal mischief? At the end, it says the defendant.
He in the police vehicle, that car camera, he ripped out the cables to it, so he broke that as well. And he has that misdemeanor charge pending.
Okay, back to this square one. What do you want to do today, David?
I believe Mr. Torres wanted me to ask to have the case reset so we could check in on the restitution. That was before we had the conversation. I don't know that that's going to change anything from the offer or from the.
What do you want to do? Well, it's up to you. What do you want to do?
You want to set it for trial?
I was hoping to get probation or something. I mean, I don't understand. Like, I don't get how. I've never been convicted of assault on public servant on my adult record.
That's not what you're charged with. Is recidivism as an assault. You have any felony conviction that is above a state jail felony is used to enhance punishment for a subsequent offense if you're found guilty of a felony. That's just the rule of law. Doesn't matter what it is.
And I believe you heard that.
What he said is a cap, and it would be for this court to decide what it is, and then I'd listen to everybody and make a decision. But there are different options, but there's two: deferred or unadjudicated probation, and looking at up to 15 years flat time. And that would be no less than 2 nor 15 the court would be looking at.
I
In
would
that.
take that offer.
Well, uh, let me try to understand what I understand the offer to be, and that might,
Why don't you talk to him? And I think it's
Yes,
best
sir.
you talk to him.
because I
And
don't.
so
want
y'all
him
don't
to-
have to do that here on YouTube. Those are the kinds of things that are kind of personal between y'all two. Y'all need to discuss it and
Yes, sir.
your life. This isn't a crossroad. You're going to either go that way or that way, and it's an important decision. And they lead in different directions. So in summary, again, David Torres in cause number 24 CR 845.
Yes,
David
Your Honor.
Grove is his attorney. He waives a formal reading of the indictment. Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that on or about March 11th, 2024, in Jefferson County, Texas, it alleges you, David Torres Jr., committed the third-degree felony of assault on a public servant. Do you understand what you are charged with in this case?
Yes, Your Honor.
Now, in addition to this charge, the state of Texas has filed shortly before this hearing this morning on July 22nd, 2024, something called a notice of state's intent to use prior convictions for purpose of enhancement at punishment and notice of intent. And that is that it is alleged that you were finally convicted of the offense of burglary of a habitation on August 12th, 2013 in the 252nd District Court of Jefferson County, Texas, in cause number 13-16367, and were sentenced to 18 years in prison. All right. Do you understand what you have been charged with the indictment, and then also included this notice of state's intent to use prior conviction? It says convictions, but it's one singular conviction to enhance the punishment range one level. And that would turn this from a third-degree felony punishment as indicted to a second-degree felony punishment based upon the notice of intent to use prior conviction, because people are sentenced in the state of Texas as well as federal court in jurisdictions across the land for the circumstances of the crime and other prior criminal behavior. That mixes into the batch to determine what a punishment should be in each case. Do you understand?
Yes, sir.
So does the defendant waive any additional time of preparation based upon this notice being filed this morning?
Yes, sir.
All right. And are you waiving any additional time to prepare Mr. Torres voluntarily, knowingly, intelligently, and based upon discussions with your attorney?
Yes, Your Honor.
So what we're looking at here is second-degree felony punishment, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, Your Honor.
An agreement's been reached where you would be pleading guilty, being exposed to up to 20 years in prison, second-degree felony punishment. Whatever sentence shall not exceed a cap of 15 years in prison. Also, the state is going to dismiss cause number 24 CR 844, the state jail felony of burglary of a building. Is that your understanding of the agreement?
Yes, Your Honor.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, Your Honor.
Also, do you see what the options are? You're looking at no less than 2 nor more than 15 years confinement in prison, up to 10 years deferred or unadjudicated probation.
Yes, Your Honor.
And what about the option of regular probation?
Judge, I believe since this is an aggravated assault against a public servant,
It's not aggravated. It's just an assault on a public servant and there was no weapon used.
then
the way the indictment is alleged is intentionally, knowingly, or recklessly causing bodily injury by biting the defendant on the hand. So the allegation is not serious bodily injury, it's bodily injury. So the way it appears to me, the way it is indicted, the without any further proof, just the allegation, I think he's probably eligible for regular probation, which is no less than 2 nor more than 10 years confinement in prison. And then that would be suspended and you could be placed on regular probation up to 10 years. So I think that is an option. But biting someone with using their mouth can certainly, we can certainly use our imagination that is capable of causing serious bodily injury or even death if
Yeah.
done in a very aggravated fashion.
Like that one guy in
So
Arkansas.
certainly if you've watched Silence of the Lambs,
Oh, yeah.
but nonetheless, that's not the way it was indicted. And I think here they're not alleging it. The inference is not because it's not saying serious bodily injury. It's just capable of causing bodily injury. So that does not rise to the definition of a deadly weapon. If I follow this agreement, you have no right of appeal of your case. Do you understand, sir?
Yes, Your Honor.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, Your Honor.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, Your Honor.
Did you understand it? Discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, the state you were mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. Also, you were taking into account this notice of state's intent to use prior convictions, a conviction to enhance the punishment range. You are aware of that and have discussed that with your attorney. You were giving up your rights to a jury trial, the right to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived? Or no, we need one. We're gonna need
Judge,
one.
we would waive one, but I think the court probably would want.
I
to
think
have
we ought to have one. Of course, you get credit for all time served. Don't worry about that, but we're going to order a pre-sentence report and return back on August 19th. Okay. And we will come back. Everybody will have a chance to sound in, and then the court will make my decision on your fate. Do you understand what's happened, sir?
Yes, Your Honor.
Okay, anything else?
No, yeah.
If not, then we are in recess on this. So thank you. How long have you been in jail now, sir? About
months.
5 months? Okay.
134.
Okay. All right, here's that file. Here's this file, this other file.